Good afternoon.
Good afternoon. How are you?
I'm well. How are you?
I am fine. You sound a little tired.
I am just a bit.
Oh, that's sad to hear. It must be full of enthusiasm at this time of the day.
Well, I had to get up pretty early to drop my son to work, so that's part of the reason.
Oh, okay. So you've fallen into that sleep mode now,
Yes, yes,
slowly but surely. Well, anyhow,
yes.
it's the first day, so it shouldn't be that long because we're going to do a recap of Company Law 1. But it shouldn't be that difficult.
Okay.
Okay, that's the alarm. I hear that alarm. That's mine. Hold on. Yeah, I think that's mine. 12:30. Okay, I turn it off. Okay, let's start. I want to write your capstone questions. I can send that to you so you can get started. I know you all are anxious and excited to get started on another capstone. Correct?
It's so early.
Okay, I'll wait another week if you all think so.
No, man, you can give it to us.
Okay, right, so I'm gonna write it this week and then email it to you all.
But I have a question, Ms. Archer, not to get too far ahead, but I know last time when you gave us the outline for the exam, would you be doing the same thing?
What do you mean outline?
I think right before the exam, we were able to know exactly what we had to prepare for, like which topics we had to zoom in a bit more than the others.
Mm-hmm.
Oh, okay. Just wanted to know.
I'm not gonna leave you to go and study a bunch of material and only focusing on certain sections. No, I won't do that to you.
Fabulous. All right, thank you.
But I won't give you any direction for the capstone though. You know, that's always in depth.
Right, I'm just, okay.
Yeah. Okay, so chapter 1 is on general company law principles, which we would have covered in company law 1. And so how I'm going to approach that today as a review is, instead of just going through chapter 1, unit 1 that you could read yourself, I'm going to ask you some questions to see if you actually understand company law before we add on in this class. Because in this class, we're going to look at other types of structures that are used along with companies, or companies that are formed and then they require another license to perform a different function. So before we go into all those different products and also talk about the corporate secretarial role, I just wanted to just go over today some of the main elements that we need to focus on when it comes to a company. So what I'm going to try to do in this class, and along with the capstone that I will give you, we're going to focus on some of the current issues that arise in company law and in other structures. So the first thing I'm going to ask you is, what is a shadow director? Who's going to be the first? Raven? Should I volunteer you?
I think it's someone that isn't officially appointed as the director of a company. I guess somebody that steps in if the director isn't available? You think?
Mm. No, he doesn't step in. He doesn't step in. He's someone who gives instructions and decisions to the other directors who accept it. And normally he doesn't carry out any actions himself. So he's normally the person that's behind the scene.
Okay.
So he's not formally appointed. So what would you call a de facto director? Now the shadow director is a person who gives instructions and decisions.
So would the de facto director be the person that's able to make the decision?
He makes the decisions as a director and he carries out duties as a director, but he also is not formally appointed.
Okay.
So, director.
Are they officially appointed?
Yes, one who is formally appointed and registered as a director. So now you have another type of director. So that's de jure, you have de facto, you have shadow. What's a nominee director?
That's the director that was appointed for the interest in the company.
A little bit more. When you think about the nominee director, remember how that relationship arises. Doesn't it arise by an agreement, a contract?
Yeah, are they appointed by the shareholders?
Yes.
Okay.
So a nominee director is usually appointed by the shareholder. And that nominee director could either be a de jure director that's formally appointed, or they can be a de facto director. Now, the reason why the nominee director is appointed, because what they do, they represent the interests on the board for the shareholder. And the nominee director always have to act in the best interest of the company. What's the non-executive director? Linda, you could remember non-executive? Only Raven one is answering, so I try and see who else.
I think are they the director that isn't involved in the day-to-day management, but they still a part of the executive team?
Right? So they're normally appointed for their expertise.
But they don't make decisions.
Oh, yes, they do.
Yeah.
They normally question the decision of the executive. That's really their role.
Sorry, I couldn't find this tab for anything when you were asking me the question. So sorry about that.
Which tab?
To get back on, to get on Zoom, I had so much tabs open, I couldn't find it. I'm sorry.
That's all right.
Thanks for that answer.
That's okay. All right, so then they ask you, what's the executive? was an executive director.
Would there be someone that,
What else?
would they give directions to more so the acting directors?
Now, when you say acting director, what do you mean?
I guess the directors more involved, like the appointed directors, like in the everyday.
Right. So the executive director is responsible for the day-to-day running of the company.
Okay.
That's the executive director. And the non-executive is normally appointed for some specific expertise. And they normally question the decisions of the executive director. So now let me ask you now, because remember now, when we started Company Law 1, we spoke about at the very beginning the differences between a company, a partnership, and a sole proprietorship. Correct? And
Correct.
remember, we spoke about a company, we spoke about the reasons why a company is formed, and then we talked about a company having two organs, the board and the shareholders. Most of the issues you'll see in company law comes from those same two organs, the board and the shareholders. The shareholders are the owners, shareholders or members, because they use them interchangeably. And they have their meetings at the annual general meeting. So if I ask you, based upon the composition of a company, be it private or be it public, what would a normal agenda look like for an annual general meeting of shareholders?
They would have a director present.
Mm-hmm. What would be on that agenda for the annual general meeting?
Good afternoon, Ms. Archer.
Good afternoon.
I think that on that agenda might also be if they suffered any losses, if how much profit they made, if any shares were issued and the value of those, and how many share offerings there may have been for the year, any projects or new products that they have planned ahead for the upcoming year, any new appointments as far as the board or any executives, and any other information financially about the organization or any other thing that's important that they may feel that the shareholders and other stakeholders may need to know as far as the operation of the company and the way forward.
Okay. All right. So that's a good point you made there, Xenia, because what the issue now they see happening in company law is that the members, they more or less now feel that the board itself has a little bit too much power. That's the confusion you see coming in now.
Yeah.
They're saying that board their money and they want more say in what happens. But everything comes back to what's in the memo and arts.
Yes.
And the memo and arts cannot override the Companies Act. Now, other jurisdictions have gone ahead and made changes to their Companies Act, bearing in mind the issues that have been raised with this power that members want. And what the members are saying is that their role as minor one, that really the only thing they do is they have actually just become a rubber stamp, because the directors make the recommendation to them and it normally just approve it. and they want to be able to have more power. So that is an issue that's coming out in a lot of the company law changes around divide that corporate power between the members and the directors.
Mhm.
So after we looked at the two organs in a company, we spoke about why it's beneficial to actually incorporate a company. And when we did that, we looked at the features of a company. One, that it has what? Continual succession. Is a legal separate entity. It has limited liability. The separation of the ownership and the management of the company. The company can issue shares. It appoints directors. It can add directors, remove directors. The same with shareholders. It can expand, it can downsize, and all that without changing its legal structure. And of course, the good thing about it is that your liability is limited.
Yeah.
It's a sole proprietorship or even a partnership. Then we went on and we said, now, how was this whole principle of a company being a separate legal entity? Where did that come from? And that's where the case of Solomon versus Solomon came about, which established that a company is a separate legal entity once it has received that copy of that certificate of incorporation. That's when it becomes a separate legal entity. Then we moved on to talk about that there are exceptions to this principle. Two of them. One, when there is an agency relationship, and where the corporate structure is more or less determined by the court to conceal the true facts. That is that it is a mere facade. So in the agency principle, anyone can remember any of the cases on the agency? No? When the court said there's an agency relationship, and that comes in when there's a principle of a parent company and looking at the structure of the parent company and the subsidiary. So you normally have an agency relationship in a group of companies. And the parent company will normally plead that the subsidiary company is his agent. And the court said that there's a few questions that you have to ask yourself in determining whether there is an agency relationship. And that is who was really carrying on the business, who received the profits, who was actually conducting the business, who appointed those persons, who was the head and brains of the whole venture, and of course, who was in effective and constant control of the business. And that's how the court determines whether or not there is an agency relationship between a parent and a subsidiary. Now, the second exception, of course, is piercing the corporate veil. And we know that historically, the court has pierced the corporate veil under certain circumstances. But we know that in the last case of Pest versus Petrodel Resources, the court was saying that in a lot of those cases in the past, there were other means that the court could have used to go behind, not to necessarily go behind the veil, but to find another reason for awarding the plaintiff a benefit from the whole arrangement instead of piercing the corporate veil. And in that instance, the court decided to use trust principles to determine that the spouse of the defendant, the benefits of the structure that was designed by her husband. So the courts will lift the corporate veil where in their determination The corporate form is being used as a sham or facade to evade the company's existing liabilities or just to defeat the law. And lifting the corporate veil is a concept where the rights and duties of a company, which are in principle the responsibilities of the company, become the rights and duties of the shareholders of a company in a limited number of circumstances. And that's where the courts have moved now to. Instead of just piercing the corporate veil, they try to limit that piercing, because what it does is it begins to erode the whole concept of a company being a separate legal entity from its owner. And so there have been instances where they have pierced the corporate veil not under just fraud, but they do it in terms of looking at where someone is trying to evade some relief or a conduct that they have done, the agency principle, and of course, the single economic unit. That's a group of companies. We also looked in, when we did Company Law 1, we looked at the Solomon Principles and also corporate liabilities. Looking at the company with regard to when it has contracts and it wishes to enforce those contracts, how does it go about doing that? Looking at the company's capacity to engage in a contract. We looked at torts. That means looking at how the company can sue and be sued. And also the liability as a joint tortfeasor with the company, that's as a director, in carrying out his responsibilities, where he can be sued along with the company, or a director can be sued by himself, or the company is being sued under criminal law. So one of the things we found out when we move on from just the concept of what a company is, and it being a separate legal entity, meaning that it can sue and be sued, we also looked at some of the key players in a company. And one of the main ones we focus on, more or less in the middle of Company Law 1, was the director. And we covered in detail the duties of a director. So we know that a director has statutory duties. But in addition to that, he also has some common law duties. And one of those common law duties is a duty to promote the success of the company. Always be mindful that the director himself, once he has been given the objective of the shareholders and the strategy has been developed, then it is up to them to actually ensure that the company is successful. So their duty is to promote the success. That duty is for the benefit of the members. So in achieving this objective, the directors always have to consider what is the long-term consequences of any decision they make. They have to think about the interests of the employees, and they have to also think about all of the other stakeholders, such as their suppliers and their customers, creditors. They also have to think about how the business will affect the community or the environment in which they work. Because in Company Law 1, we also remember on the research question, we looked at how companies have actually been brought to court for environmental violations. So in promoting to the success of the company, they also have to think about the reputation of the company and the need to maintain it, especially for high business standards. And also the need to act fairly as between additional members or between the members of the company. The next duty that they have is the duty to also act or exercise independent judgment. And again, they have to do this in the interests of the company. This is an example of that, what they call the general duty to act in good faith. So normally it's a breach of duty for a director to act on instructions of some other person, unless the director actually showed that they exercise their own judgment in following the instructions. So the duty applies to a director who is appointed as a third party or even as a nominee. They have to ensure that they do not put the interests of the third party before those of the company. So a director always has to be mindful that whatever decision he makes, it has to be in the best interest of the company, and he exercises independent judgment. A director can, however, he can enter into an agreement that restricts the future exercise of discretion by the directors. And we saw that in the case of Fulham Football Club versus Cabra Estates, 1992, BCC. There, the directors signed an agreement to develop the football ground and then gave an undertaking that Fulham Football Club Limited would not oppose the development at a later date or support a compulsory purchase order. It was held that the directors had not improperly restricted the future exercise of their discretion. The directors also have a duty to exercise reasonable care, skill, and diligence. That is a statutory duty. Now, this was also in common law subject to what they call the test of reasonableness. And this test is a subjective one. So a director is expected to display the care, skill, and diligence that a reasonable, diligent person carrying out the same function would do. He should also have some general knowledge, some skill and experience that he possesses. It is expected that if a director has more experience, skill, and knowledge, that they would actually exercise greater levels of care and skill and diligence. The next duty that a director has is he has a duty to avoid conflicts of interest. And I know you would have noticed in the last amendments to the Companies Act, you saw where the legislation is now included the duty to declare when there are conflicts of interest. So under common law, a conflict of interest is defined as being where someone holding a fiduciary position enters into an engagement in which he has or can have a personal interest conflicting, or which possibly may conflict with the interests of those whom he is bound to protect. A conflict of interest only arises where it could be reasonably foreseen. And this duty also applies where the company cannot take advantage of such property, information, or opportunity. Now, when there is a conflict of interest, if the company is a private company, a director can disclose his potential conflict of interest to the other directors around at the meeting. And then they can authorize the transaction. Sometimes the person can actually stay in the room, depends on the matter, or they can actually remove this right from the directors. Articles of association. So that is a matter that actually goes to the members to make a decision. A potential conflict of interest can be referred to the board of directors if and only if there is a specific provision in its constitution devolving this authority to the board of directors. At a meeting to consider a possible conflict of interest, the relevant director and any other interested directors should not count in numbers necessary to receive a quorum, because normally they're asked not to be in the board meeting. The interested directors may vote on the conflict of interest, but there must be a majority for the decision, excluding their votes. Approval by the board of directors cannot be set aside by any common law rule or equitable principle, requiring the approval of the company in general meetings. Another duty of directors is not to accept benefits from third parties. Director, as you know, is accountable for any undisclosed profit obtained by virtue of his position as a director. And we always call this the secret profit rule. The undisclosed profit includes benefits taken in good faith, as well as bribes and other underhand payments. A third party includes any associated corporate bodies, a person acting on behalf of the company, or an associated corporate body. So given the similarities between the duty not to accept benefits from third parties and the duty to avoid conflict of interest, it is noted that there is no provision for the authorization by the board. Any sanction given to a director for a potential breach of this duty must be given by a general meeting of the company, unless there is a suitable provision in the Articles of Association. Another duty that a director has, he has to declare an interest in a proposed transaction or arrangement with the company. So he has to declare, the director has to declare the nature and the extent of that interest to the other directors. The director doesn't have to be a party to the transaction or the arrangement for this duty to apply. As long as he has an interest in this transaction, be it direct or indirect, he has to declare. And that declaration of interest must be made before the company enters into the transaction or the arrangement. I'm trying to see if there's any more that I could remember that we went over in the last class. I think that's like the majority of them. Any questions? No questions so far. Okay. The last part of company law 1, we looked at shares, issuance of shares, types of shares. And then in the last part, we looked at liquidation, the whole liquidation process. So my question to you today is, if a company has been struck off due to non-payment. And there's a requirement now from the country where they do business to provide a certificate of dissolution. How can they go about that in the Bahamas? If they have a Bahamian company that was incorporated here, was struck off, but now they have to prove to the registrar in the country where they do their business that the company that they have a certificate of dissolution. How can they go about doing this?
Well, they only can get that certificate if it's liquidated, correct?
Correct. And so how are they gonna go about this?
To go about with the liquidation.
How are they gonna do it?
So, okay, this is my question, because I kind of know the process to liquidate, but because the company is struck off, would they have to restore it first, or they can just jump right into that process? They would have to restore it.
Start first.
Okay.
Okay.
So once they restore the company, they would have a resolution of the directors appointing the liquidator. I think there's a resolution of shareholders as well, confirming the liquidation, but all the assets would have to be removed from the company.
Okay, so let me give you this case. It's very short. It's a Bahamian case. This was in the matter of the IBC Act and Barrow Holdings Corp. So in this case, this company was incorporated in what year it was? 1996. And it actually issued bearer shares. And all of the bearer shares were purchased by this company called PRSA. The company was struck off the register in 1998, 2 years later, because they had not paid their fees in 1997. And so now they had to provide to their home authority that the company was dissolved. So that's when they found out that the company was struck off due to failure to apply to the registrar within 5 years of being removed from the register to have the company restored. They're already past that also. Because this action actually took place in 2007. And the shares were in bearer shares. They hadn't been converted. Because remember, the law changed in 2000. So they had to apply to the court in order to have the company restored and have the shares converted from bearer to ordinary shares and then liquidate the company. So this is a Supreme Court case, 2007, number 480. It's online. And the court permitted the reinstatement of the company to recall its bearer shares within 6 months. And then registered shares substituted thereof. And then of course, put the company into liquidation, even though there were no assets.
So I have a question.
Go ahead.
When a company is struck off due to, of course, not paying their fees, and they do this so they can avoid the fees of liquidation, does anything ever come out of that? if no one is requesting a certificate or anything, like, can they just do that? Like, let their company be struck off?
Yeah. And then
Okay.
like this company here, the 5 years had passed.
Okay. So only if a dissolution certificate is requested, then this would probably happen.
Exactly. Because I was looking last night to see if I could find exactly what you said, one like that. I saw a few of them, they were very, very long, so I have to go back. But this one jumped out. But the registrar struck it off. But let me tell you what happened. In this case, the company, after it was incorporated and they issued the shares for purchase, right? They realized that they didn't need the company anymore. Because they had sold all of the assets.
Okay.
So I guess that's why they didn't bother to pay the fees the next year, because it was incorporated in 1996. They didn't pay any fees in 97. And so in 1998, the year after that, it was struck off. So now they making a request to the courts to liquidate. And they're willing to pay the annual license fee and the penalty fees for that period, because that was required by the registrar. And they said that the reasoning for the liquidation of the company, which holds no assets, is that the company was used as a vehicle to hold shares in another company. And then once those shares were sold, the company was of no use, but they didn't bother to go through the liquidation process. But to conform with the accounting principles of the jurisdiction for the company which purchased the shares, they were asked by that registrar to provide a certificate of dissolution. And that's the reason why. But other than that, I don't see how the government would have been able to get the fees for those periods. Only because it was required by law in that country. Now, like the point you were making, I don't know how many other companies we have that was struck off, but never liquidated. So they had to do two things. They had to restore the company, and then they had to reissue the shares, because the shares were bearer shares. So it was caught up in that period between the law, when the law changed. In another case called Fund Haven Limited versus the Executive Director of Securities Commission, this one you can look up, I think it's about, can't remember, 20 pages. It's kind of long. But in this one, this was a investment fund that was established, and Winterbottom was appointed as its administrator. And Winterbottom registered the fund. Now, what this company did was it terminated. No, Winterbottom resigned as his administrator. And what the company did was 2 directors of the fund formed their own company. So they applied for a license as a restricted investment administrator. And then they in turn went to license the fund. And of course it was denied because they were registered as a restricted investment administrator. And eventually the Securities Commission licensed it as a smart fund number 5, because it was initially registered as a smart fund number 3. Hold on, let me see if I can find it here. Okay, here we go, fund. So this was the fund called SAIF, and it was a private investment holding vehicle for an Argentinian family. And let me see, it normally don't tell you it in what the issue is. Oh, let me see if I can get it in a summary. I think the issue is whether or not this was still a fund. Oh, it's 19 pages long. So in this one, one of the issues was whether the judge certify a point of law general public importance for the purposes of section 21(1) of the Companies Act. You have your Companies Act handy?
No, let me pick it up.
I'm trying to see. If you key in Fund Haven, FUNDHAVEN Limited versus the Executive Director of Securities Commission, you'll be able to pull up this case. It's a Privy Council case.
Fund Haven, HAVEN.
Yeah, Fund Haven is one word, limited.
Versus
Executive Director of Securities Commission.
okay. I have it up.
Okay. So from paragraph 34, that's page 14.
Oh, this
That's-
is the summary one.
Yeah, I was trying to have a summary as to what the key issue is. So paragraph 37, it asks the question, did the judge certify a point of law general public importance for the purposes of section 21(1)? I'm trying to see where. Because what I was trying to do is find some Bahamian cases instead of giving a lot of English cases. Oh, okay. It is saying that there was no certificate to be discharged. I'm just trying to see what exactly was the point they spent all this time to the Privy Council on. Let me see. Oh, it's of the Court of Appeals Act, second appeal. Okay. I probably got, you know what we're gonna have to do? I'm gonna have to go and pull up the Court of Appeal decision. This one is not giving us enough information. Oh God, it was just there. Just had it. Okay. All right, so turn to the Court of Appeal decision. Just use the same heading and just put plus Court of Appeal.
I have something called Court of Appeal of the Commonwealth of the Bahamas judgments. Have I entered the wrong thing?
Yeah, no, but just put in Fund Haven versus Executive Director of Securities Commission and put a plus sign and then put Court of Appeal, the case comes up.
Okay. You have issues and facts.
We're using
The
issues
only
and
thing, yeah, the only thing coming up for me is saying Judicial Committee of Privy Council case details, Fun Haven Limited versus the
no,
Executive Director. No, yeah, this. I'm pulling that up.
the
Are you able to share your screen?
Court of Appeal and two different thing.
Okay.
So that's all I put in, you know.
Yeah, I have Fun Haven Limited versus Executive Director of Securities Commission plus Court Appeal.
Court of Appeal.
Yeah, Court of Appeal.
Case
And
number
that's the first thing.
case number 252 of 2013.
I'm picking it up. I'm not picking up the exact page I guess you have, but I can see where it has case number 252 of 2013.
Okay,
So,
you're on the Court of Appeal page, right?
right.
Okay, so click the little PDF.
Okay. All right, I'm here. Fun
Okay.
Haven Limited.
So it says that the intended appellants were found guilty and they were fined. Okay, so they were fined. And then they appeal it. Okay, let me see what the certificate in the second motion for leave to appeal, paragraph 8. On that day, the counsel for the intended respondent, Mr. Ward, he questioned the authenticity of a second certificate. I think I'll have to read this after class to see what this certificate is of public knowledge. I don't know what that one is. I'm gonna have to look that up. But the question that you raised about the fees in terms of whether or not the companies that have been struck off, have they actually gone through liquidation? I'm gonna have to look to see if there are any court matters that actually address that issue before our next class, because that's a very good point. Because only because this matter required it by law. Okay, are there any cases struck off? So, but your question is really asking whether the registrar goes after those companies?
Yes.
Okay, so you want it from the registrar point of view. I don't think I saw any of those when I did my research, but I will look.
Okay, thank you.
Hold on, don't go yet. I have another case here. Let me see if this one took it from your angle. No, this one is a little bit different. This one is, let me see if you could find this one. Supreme Court, 2007. And it's called In the Matter of Soothsayer, SOOTHSAYER Limited. See if it comes up. Supreme Court of the Bahamas.
Yes, I have it.
You
Let me
have
share-
it?
I'll share the link.
Okay, and it's have Mr. Bidzina.
Yes.
All right. So in this case, it says the company was incorporated as an IBC, and purpose was to hold certain assets, namely funds and investments of the Mandalay Trust. The plaintiffs are the sole beneficiaries of the trust, and the company maintains accounts at Credit Suisse, Singapore. The company was voluntarily dissolved in 2015, and 4 months after its dissolution, the first plaintiff discovered that there had been fraudulent activity in the management of his accounts held with the bank, including unauthorized purchases of shares, imprudent trading activity, and false reporting. An employee of the bank admitted guilt in a criminal matter before the Swiss court. In the interim, civil action has commenced against the bank in the High Court of the Republic of Singapore. The plaintiff seeks a restoration of the company to the register for the sole purpose of joining in proceedings currently before the High Court of Singapore. So we back to your point again. It appears again for the second time that it was not initiated by the registrar. The registrar objects to the restoration on the grounds that 1, there is no conclusive evidence of fraud, and 2, the plaintiffs are not the proper parties to bring the action, and as such, they have no standing, even though the liquidator has stepped in and supports the application for restoration of the company. The registrar accepts that there is no provision in the IBC Act and its subsequent amendment to restore dissolved IBCs to the register. Under its inherent jurisdiction, they may do so where it conclusively determined that such company was in fact dissolved on the basis of fraud. So what was held? The order for the restoration for the limited purpose of commencing, defending, or joining in litigation, which has already commenced before the courts in Singapore. So this is their reasons why they did it. They say in the absence of legislation dealing with the restoration of dissolved companies, the court has an inherent jurisdiction to make an order for restoration of a company which has been voluntarily wound up and dissolved, where the dissolution can be impeached on the ground of fraud. Second, it is not uncommon to find that equitable remedies may sometimes be embodied in statutes, and where they are not found, the court corrects an error where there is a need or a lacuna, that's a loop in a statute, so as to bring about a just and reasonable result. And 3, once a court has been persuaded that it is just to restore a company, absent special circumstances, restoration should follow. And then 4th, under common law principles, a person with an interest may apply to restore a company to the register. The plaintiffs are therefore proper parties to bring this application. In any event, the liquidator, unarguably a proper party, supports the application for restoration of the company. So again, this is, I mean, it's not the same as the other one, as borrow, but this again is being initiated. This one is in support by the liquidators, but this is actually by the beneficiaries seeking for the company to be restored. So 4 months after the company was dissolved, they discovered that there was some fraudulent activity. Join the paragraph, page 5, paragraph 7, the salient facts. So the company was incorporated in 2004. It held assets, namely funds and investments of the Mandalay Trust. Wound up in 2015 and subsequently struck off. 4 months later is when they found fraud. An employee admitted guilt. So if you turn to paragraph 13, it gives you the issue. Is whether dissolved IBC can be restored to the register of companies under the current statutory regime. And then if it can't, does the court have the inherent jurisdiction to restore it? And the answer was yes. And whether the plaintiffs are the proper parties, and the answer was yes. So again, it's in using the same legislation, paragraph 14. The good starting point is section 166 of the IBC Act 2000, repealed, as it was the only section which contained provision for the restoration to the register of a company which has been dissolved. And it says that if a company has been dissolved or the period of 5 years has expired, the company or creditor, member, or liquidator may apply to the court of the name of the company restored to the register. But then it tells you that the whole entire 166 was repealed and replaced by the new 166 in 2010. And then the new section 166 states that if the name of a company has been struck off the register under section 165 subsection 2, the company or director, member, or liquidator may within 5 years immediately following the dates of the striking off apply to the registrar to have the name of the company restored. And I noticed the difference in the wording is the word immediately. So even if looking at the way this is worded in 166, it appears as if the action is always taken by the shareholder themselves or the liquidator or creditor. The company, creditor, liquidator, or shareholder. It doesn't seem to come from the direction of the registrar. You see that, right?
Yes.
Paragraph 18. But I really have to look to see if I could find one that was struck off. But I don't think so, because everything seemed to be initiated from the opposite side.
Yeah.
Yeah, that'll actually have to be a project. Because you have to wait the 5 years. But the thing is, after waiting the 5 years, because it now says immediately, does the registrar go behind these people? There's no provision in here for it. They'll have to go to court. Yeah. So this was dissolved and then put back on. Dissolved and then restored. So we also in company law 1, we looked at unlawful distributions. By shareholders and their duty to repay. That's a good one too, though. What I will do is look and see if I can find any case at all. But this is a good case to read about a company that has been dissolved and then restored. And this was due to fraud. Okay, so. There are quite a few cases that have come up in the local courts, but most of them deal with securities. If not securities, some of these are in the matter of trust. We're gonna look at foundation versus trusts a little bit later. I'm gonna see what else I can find. I know today was the first day. Chapter 1 just goes over what is a company. But if it's been a while since you looked at the topics in company law 1, just focus more on liquidation, restoration, because that's where a lot of the issues come in when you talk about these other types of corporate vehicles that are used. So that's 2 cases I gave you to read. One is the Barrow Holdings Group. That's very short. That's only 5 pages. And then this one here with Soothsayer, which is 22 pages. That's not long though. Don't be afraid. And there is another one I have for you that I want you to read. Hold on, let me find the name. Here. Bank Haviland, Bahamas. Bank Haviland, Bahamas, Havilland versus Christopher Mazurier. Tell me if you find it. Found it?
Yes, found it. Let me send the
Okay.
link.
Now this one is about, I think the topic on this one is the business introducer agreement. This is about damages. The defendants, they were seeking damages for breach of fiduciary duty. Yeah, Bank Haviland was suing those individuals for breach of fiduciary duty in their capacity as directors. So let's see if we can quickly go through this one. Everybody has the link? You sent it out, right?
Yes, it's sent.
Let's see now. There's a lot of blah, blah, blah. Zoom meetings. So let's see if we get to the real thing. So what happened? It's only 5 pages, so when are they going to say it?
Good afternoon.
Good afternoon. Or they went into case management.
Once I hit that page, how do I find it? I hit the link, but I'm on Judiciary, the Bahamas.
Okay. So the case doesn't come up.
Yeah, once you go on the Commonwealth of the Bahamas and the Supreme Court, that should be the first thing that pop up.
And
Okay, I'm on the welcome page popped up.
Uh-huh.
So do I scroll down latest headlines?
That's strange. Oh, let me see something.
It has a search, right?
Check that out. Check that one I just sent.
Okay.
See if that works.
Yeah, I having the same issue as well.
It's not coming up.
No, I can try the new link and listen.
If not,
It's coming up, but it's like she said, that welcome page with the Judiciary of the Bahamas, but I couldn't see where to go to the case.
Okay, your second link, it brings
Okay.
me up to a PDF, so that's what I'm opening.
All right. Try.
so this was the issue here. So the bank is suing those defendants, and those defendants are the directors of the bank. And they said that they're suing them on the ground that one, by causing, procuring, or permitting the bank to enter into a business introducer agreement with Palms Foe Limited. Secondly, for causing, procuring, and or permitting Bank Haviland to enter into a business introducer agreement with PFO on or about July 2016. The first one was in 2014. And then the third matter, they said causing, procuring, or permitting the Bank Haviland to make payments to Palms FO and or PFO pursuant to the said agreements. And Bank Haviland claims against Palms FO and PFO arise in connection with their knowing receipt of monies paid pursuant to the agreement. And it seeks a declaration against these two defendants that such monies are held in constructive trust for the benefit of Bank Haviland. So do you understand what constructive trust means? That's paragraph. I read that from paragraph 1 under the ruling. To find this matter has been going on for a very long time. Paragraph 13 and goes on to COVID. Oh, this is a mix-up. How far are you up? Okay. Did you read what decision the judge made?
This if a settlement is not reached by 10:45 a.m.
Mm-hmm.
Then the trial is action.
Yeah, but she's saying that, okay, so the directors are being sued by the company itself, right? And without even getting into reading all of the documents that they submitted, you could see from what's being tabled here that the company is alluding that whatever arrangement that they went into with that company PFO, the business introducer, that either they were directors of those companies themselves. You see what I'm saying? There's some conflict going on. Or whether BFO itself did not provide any services. Or whatever services that they claim to have, that didn't happen. But what happened during the whole process is the whole thing is being lagged behind. Someone is sick, they're in different jurisdictions. People can't come together to actually have the trial begin. And what the judge is saying is that, all right, this is a financial center. So one, is the reputation of this jurisdiction is on the line. Two, you have lawyers making a lot of excuses. Three, you all decided that you always start to go into negotiation to come to a settlement, which is what the court likes, but you didn't inform the court. So you spent all of this time and money going between A, B, and C, A, B, and C. You didn't inform the court. Now to come to find out, the court is now pressing that trial must begin. So the bank's lawyers are ready to proceed with trial, but the defendants are not ready to proceed with trial. Then they say, no, we're going back to negotiate. Then they come back now and say, we're going to trial. So the court said, you're wasting our time. And that's why the judge said, this is what it is. Because then now, what's going to happen is that the shareholders of Bike Haviland themselves, and now if they take too long, they're going to come back now and they're going to want to be a party to this matter because now they will want to sue because of the actions of the directors. So which duty did they breach without having all of the supporting documents? Just looking at paragraph 1, which duties do you think those directors breached?
Is it fiduciary because they had some type of connection?
Yeah, it could be a breach of fiduciary duty, and it also can be a conflict of interest. Because they say they caused, procured, and they permitted the bank to enter into this agreement with this company. So fiduciary, most likely, and it may be a conflict of interest. Just remember now, a lot of people, what they look at, they see an opportunity, and so they say, okay, we could form a company, or we have a company, and they may not have a direct interest, but they may have an indirect interest. But this would be a good one to watch. Let me see when that one comes out. He said July, September, but that may come out very shortly. July 27th. You have to look for that one. Now there are some trust cases, but we'll go through those later when we look at foundations and trusts. But let me see if I could find one of them so you could get an idea that this whole thing of having a company and being a director is not an easy job. As you can see, you can be sued. Okay, this one is called in the matter of the trust and deed of settlement, establishing the X settlement, Supreme Court, 2020. In the matter of the trust of the deed of settlement, establishing the X settlement, Supreme Court. You found it?
Yes, I have it. Yes.
I bet it. So this one is where the question is being posed to the court, asking for direction. So it was a discretionary trust, and it's for the benefit of X and her issue. So the settlor wrote a letter to the trustee and expressed concern over the fact that a trust established for the benefit of X's brother, Y, which is also administered by the trustee, contains near identical provisions to those of the X settlement, was at risk in potential.
Sorry,
loss.
Ms. Archer. The link
Mhm.
didn't come through properly. Can you resend this?
Okay, let me do it. Bahamas. Wait, hold on, let me just do it this way. Save Bahamas. Okay, hold on. Go here. I hear a horn.
Yeah, that's outside my door.
Try that one.
I send one too. You see that one?
Yeah, the second one came up.
Okay. Now this one we could look at in more details when we do trusts. And then I'm gonna see if I can find one for you, if we have one locally, if there's been any legal matter on foundations. This is a trust one. So when we do trust, we could go through this one in detail. This one is 35 pages, so you know it's long. So you have a couple of weeks to read this one. Are all of you familiar with trust?
No, I've never dealt with trust or foundations, so this will be a first for me.
The first view, okay. So we'll look at that. What about you, Raven?
No, I've never dealt with trust at all.
Okay, all right. So,
First for me as well, Miss Archer.
okay, so that means that for trust, we're gonna have to, you may have a lot of questions. Have a look at chapter 2 for next week. That is
Okay.
normally, and then we normally do non-profit after that. Everyone familiar with non-profits? And then after that, we do trust and foundations.
Mrs. Archer, does class normally start 12:30 moving forward, or is it 12 o'clock?
12:30.
12:30.
Yeah, 12:30. So the fourth class is on trust and foundations. I'll try to find a foundation case, but this is a good trust case because it goes through a lot of the principles. So, yeah, it's not that bad. And so I'll try to explain to you the essence of how a trust works. And then you'll also look at the foundation and then look at the differences between a trust and a foundation because they are different. So you have another 2 weeks to read this case. And any questions you have, you can write it on the side. So then when we go through the principles of what is a trust and how it operates, and then you begin to understand the issues that come up with a trust. Some of the issues. And we will compare it with a foundation, which is another corporate vehicle. So what I'll try to do is try to find local cases if I can, which will help you all like understand some of the issues that arise with these products. I think the local ones sometimes make it easier for you to understand, hopefully. Okay, I got that up for you. Okay, so I'm not gonna work you too hard today. For those who need the refresher, they can read chapter 1 and let's move on to chapter 2 next week, which won't be too, it's not that heavy. And then after that, we'll move into the actual products and comparing and contrast the products, the features, what they're used for, and then the issues that can arise. I may have to go through some cases from other jurisdictions. If I can't find the concepts I'm looking for and the local ones, I may have to use some overseas, some privy council cases from other jurisdictions.
Ms. Archer, I have a quick question.
Go ahead.
I'm new to corporate, so what material do you suggest that I go through?
Now, when you say you're new to corporate, you didn't do company law 1?
No, I haven't.
Oh, okay. What reading material you have?
I downloaded the one that you sent, and I also downloaded the IBC Act.
And you need the Companies Act. But see, the
Okay.
thing about in company law 1, you'd have gone through both acts, right?
Mm.
And so again, company law 2, the first class is really just going over some of the issues that now arise with a company that has been already incorporated and operating. Company law 2 looks at other corporate vehicles. So we're gonna look at nonprofit organizations. We're gonna look at trusts, look at foundations. We're gonna look at the corporate secretariat function. We're gonna look at investment companies. I don't see what you could read. Okay, what we can do is ask Mr. Pratt to give you the notes for company law 1,
Okay.
so you can read it. And then you'll have an idea. If you have questions, you could ask questions. You could shoot me an email.
Okay. Thank you so
Right.
much.
Yeah, so that'll help you. Anybody else?
Ms. Archer, is it possible we could get those links via email as well
Which links?
that Linda shared with us today?
Yeah, I'll send you the actual documents.
Okay,
Yeah, I sent you one already. You got that, right?
let me check and see.
Yeah. I sent one. And I'll just send the other 2. And if I find any more, I'll try send them before class. But it takes a while because they're not that easy to find. You see it? Okay, so Charmaine, you need company law 1, right?
Yes.
Yes, I got it.
Okay, so what I'll do is on that same email, I'll come back and I'll add the other 2. I'll add the soothsayer and borrow.
Okay, thank you.
Okay, what about Fund Haven? You have that one or you want me to send that too?
Send that too, please.
Okay, Fund Haven. Okay, I'll do all of those.
Okay, thank you.
All right, and then if I find any more through the week, I'll send those also. Because I think
Okay,
you read the notes really only just give you the general feature and the law that's behind it. But when you want to make it practical, you need to see the issues that arise from these instruments. So I'm going to try and see if I can get some cases on it. Now, do not get paranoid or overwhelmed to think that these cases are going to be on the exam.
you know that was going to be the next question.
No. If there's a particular issue that we come across, and then if I'm going to put it on the exam, I will tell you.
Okay,
Yeah. So
Mrs. Archer, question.
Yeah.
In reference to the exam, how far in advance would we know what to prepare for studying?
Okay, you have a midterm and you have a final. The midterm is normally on the first half, the first 5 chapters. The final exam is normally on the last 5. So I don't think Mr. Pratt has sent out the schedule as yet. So normally you would have the midterm, I think it's a week. The maximum is 2 weeks. For the final exam, I think you have, it depends on timing. It may be 2, you may have a 2-week time to study. Be mindful that on the last class before the final, we go over what's coming on the exam. So you're not all over the place. You know exactly what's coming. You just have to study.
Okay, thank you.
For the term, if I'm not covering a particular section or chapter, then I will tell you there's no need to study it.
Okay, thank you.
Yeah. So you already know now for midterm, you're going to have a pure company law question. And it could be where the company is suing the directors or the directors are being sued, or it could be related to the members themselves seeking to have more power. But whichever one it is, I will tell you before you do the midterm. So there's no need to panic at this moment. Okay?
Thank you.
All right, so let me just send you the rest of these cases. And then any more. Okay. So for now, have a good weekend. Let's send a note to Mr. Pratt to send this thing to you, Charmaine, so you could get started on that. And if you have questions, you can email me.
Okay, thank you.
Be prepared. Lots of work ahead.
Great, thank you. Have a
Okay,
great day.
okay, thank you. Have a
You're
great day, guys.
All right. Let me see if this is Fund Haven.